Good afternoon. It's a great pleasure to be here with you today as your chair. Thanks, Federico, for asking me to be chairing this very exciting and extremely important panel on human rights and cross-border cooperation provisions. We have 3 papers in this panel, but 2 presenters are here at present, and 1 presenter will be shown to you as a recording after those 2 presenters. We first have the presentation by Professor Imelda Maher from UCD on the common travel area. Then we have the presentation by Professor Rory on North-South cooperation. Then we will have the Q&A session. There, I would encourage you to send me your questions directly as a message, and I will then read them out in our discussion. And subsequently to that, we will have the 3rd presentation by Aoife O'Donoghue. Let me just introduce the panel because we have 3 highly distinguished speakers. I'll start in the order in which they present their papers. Imelda Maher is the inaugural Sutherland Full Professor of European Law. She took up the chair in 2006, and she's also the former Dean of Law that she was in September 17 until September 21. She's interested in the relationship between law and governance and has published very extensively in competition law and also on EU governance with her recent work on treaty ratification in the European Union, also together with Durham and Hodgson, and implementation of EU law in Irish courts with Ronan Reardon. The second presentation then will be by Rory O'Connell, who joined the Transitional Justice Institute and also the School of Law in 2013 as Professor of Human Rights and also Constitutional Law. He has held the role of the director there from February 2014 until February 2020. In July 2017, he was appointed the Research Director for Law. And then the final presentation that will be as a recording afterwards is by Aoife O'Donoghue, whose research centers on public international law, on constitutionalism and feminism, with a particular interest in global law, global governance, and legal theory. Aoife's work examines constitutionalism, global tyranny, utopias, feminism, global legal theory, and international legal history. Now, I'm really excited to hear the presentation, so without further ado, I hand over to Imelda. The floor is yours. Thank you.
Thank you very much for that, Christian. Thank you, Federico. In fact, Federico, thanks to all your team for such a smooth operation. It's been wonderful to work with them. I'm very happy to be here today to talk to you about the common travel area. Just sorry, we're still not at the point where we can be in person, but we'll do our best. So what is the common travel area? It's about common travel. You know, it is what it says on the tin in that sense, but it also comes with associated rights and privileges for Irish and British citizens only. If you're not an Irish or British citizen, you fall outside the remit of the common travel area. It has been changed by Brexit, which is why it's relevant to this discussion, but I would suggest it's a largely uncontroversial part of the Ireland-Northern Ireland Protocol. It's long-standing and freestanding UK-Ireland arrangement. It dates from the establishment of the Irish state. It's now, thanks to Brexit, it's become more formalized, but it is still scattered with a mixture of legally binding and non-binding sources, which is what I'm going to talk about today. So how has the CTA been codified? Well, I'm going to talk briefly about treaties, constitutions, and legislative changes, MOUs, memorandums of understandings that are backed by legislation and others that are non-binding. And in order to tease out the following question, given uneven codification, how is the common travel area insulated or affected by the continuing uncertainties around the Ireland-Northern Ireland Protocol? So I will talk about each of these in turn, as I've just mentioned, just to working, if you like, from the top, as in international law, down through constitutions, legislation, to soft law at the bottom, which is non-binding. And this is quite a well-known infographic. These are the Protocol 20 of the TFEU is where we will start, which is the Treaty on the Functioning of the European Union. Essentially, this conferred, or the British and Irish governments asserted, is perhaps a better way to put it, an opt-out from the Amsterdam Treaty from the Schengen area, which is the area without borders found across the European mainland. And you can see the infographic here, and we have the common travel area shared by the UK and Ireland. So the Protocol 20, it's interesting, I think, to note that the first time the common travel area is mentioned in an international treaty, it's mentioned in an EU treaty. And essentially the EU acknowledged that the CTA exists, and provided EU free movement rights for non-British and non-Irish nationals were respected, the British and the Irish could do as they wished, which they have duly done. The construction of Protocol 20 itself is, I think, a bit odd, frankly. Its primary focus is on the UK, and then in the first paragraph, which is extensive, and then there's a much shorter paragraph relating to Ireland, saying that because Ireland is in the common travel area with the UK, it will remain within that arrangement rather than going for Schengen. But then the Irish tacked on a declaration saying that they intended to participate as far as they could with the EU area of freedom, justice and security. And initially the declaration made specific reference to the common travel area, but there was a later declaration under this one, and the language was changed to the fullest extent possible. I think it may be a bit trite, but sometimes that's no harm, to say that this Protocol 20 will at some point need to be updated to take account of the fact the UK is no longer a member state. So Ireland has made a very clear and distinctive choice, which has been supported by the EU, to stay with the common travel area rather than to move into the Schengen arrangement as it's known. Why? 3 reasons. Geography. There's 500-kilometer border, which the length per se is not the issue. The issue is that there's so many informal crossing points. It's difficult to police. For history, Ireland was in a union with the UK from 1801 to 1922, and Northern Ireland remains part of that union. And thirdly, politics, in particular, the Belfast Good Friday Agreement, of which more anon. So what we can say about Protocol 20 is that it is the first step to codification of the common travel area. It has facilitated the smooth continuation of the CTA after Brexit. But now it's important that it is read alongside the Northern Ireland Protocol, which brings us to that said protocol. So the second protocol of relevance to the CTA is the Northern Ireland Protocol. Article 3 specifically deals with the common travel area. And like Protocol 20, it says that the UK and Ireland can continue with the CTA, provided they fully respect rights conferred by EU law on EU citizens, and the UK expressly acknowledges Ireland's EU law obligations and that they will be honoured. The third international agreement is that of the Belfast or Good Friday Agreement. Now, there's no reference whatsoever to the common travel area in this agreement, but there's 2 elements that are relevant for our purposes. First, the Good Friday Agreement, as people know, says that the border security arrangements will be dismantled. This makes the border invisible. Secondly, it allows for a choice of citizenship for those born in Northern Ireland. They can be British, Irish, or both. Now, we know from the recent D'Souza litigation that there is some controversy as to whether one is born British in Northern Ireland and then chooses, or whether one can choose on birth, or your parents can choose for you. But nonetheless, the fact of choice, at whatever moment it's triggered, is significant because it ensures that those who choose to be Irish living in Northern Ireland are treated in exactly the same way as if they were a British citizen. So the CTA implicitly supports the flexibility around choice of citizenship, which is an important element of the Belfast Agreement. And finally, the last international treaty we need to concern ourselves with is the Convention on Social Security from 2019. This sets out all the social security legislation to which it applies, based on the principles of reciprocity and equal treatment of citizens from each of the 2 states. It's incorporated via statutory instruments in both jurisdictions. And now this is simply an update of various conventions along these lines since 1960. And perhaps the significant change we find in this one is an explicit acknowledgement of the EU law obligations of Ireland, consistent with the language of the Northern Ireland Protocol. So that's 4 international treaties, keep counting. Next, we have a constitutional provision that's relevant, Article 9(2) of the Irish Constitution. It sets down the citizen provisions, which is that in order to claim citizenship, birth on the island plus one parent, you need some sort of parentage link as well, or somebody who would be entitled to claim Irish citizenship. What is significant, we don't have, the British don't have a written constitution as such, so legislation is what becomes significant there. But it is worth, I think it's important to note that there's no specific legislation on the Common Travel Area in either state. So what kind of legislation do we have? The legislation focuses on status. In the UK, there's an extraordinary line in the Ireland Act of 1949 that refers to the fact the Republic of Ireland, which is the official name of this Irish state in the UK, is not a foreign country. And this phrase is referred to in the explanatory memo of the 2020 Act, which has a long title, I won't read it out. So, you know, it is still salient for the purposes of British policymaking in the UK. The 2020 Act extends the scope of free movement rights of Irish citizens in the UK to say that they don't actually have to be resident in Ireland in order to trigger those rights, that the Common Travel Area applies to them even if they're coming from somewhere else. I just thought I'd put in the stats, they're a little bit dated, but just to give you an idea. So Irish born in Britain, and I think that's the more relevant figure for the purposes, well, for East-West purposes. I didn't look at numbers of Irish or British in Northern Ireland. 380,000, we have 103,000 British in Ireland, so it's the second largest minority group in this jurisdiction, just to give you a flavour of relatively small numbers, but certainly in the Irish context, the Common Travel Area is seen as very important. What Ireland has done is update its legislation, which was very convoluted historically, to say that the term non-national used in statutes does not include UK citizens. So no conferring of a positive right, just a kind of clarification around definition of what is or is not included. So that's the status legislation, which brings us then to the Memoranda of Understanding, the MOUs, of which there are 3. There's the CTA MOU 2019, the Healthcare MOU 2020, and the Education MOU 2021, so 1 a year. The CTA MOU is essentially the umbrella MOU on the Common Travel Area. It's the first time there's an attempt to set out the nature and scope of the CTA, driven in part by the requests of the EU, because they didn't know what really were the Irish and UK talking about. A similar concern didn't seem to arise back when the Treaty of Amsterdam has been signed, but we leave that be. The MOU sets out governance. So we have an oversight committee to meet annually, and this complements a more long-standing Common Travel Area forum on immigration, where the Irish and British coordinate on visas and immigration, for which I think, again, to state the obvious, high levels of trust are required, but seem to be present. We need just to note that the CTA can be a trap for the unwary, and quoting Hogan J. in the Pechero case in 2011, where 2 Bolivian students made the mistake of trying to go from Ireland to the UK via ferry in Scotland and got picked up. And of course, there was no border controls of any description as they moved into Northern Ireland, but they aren't covered by the Common Travel Area. He did refer to the complexity of the CTA as requiring legal archaeology, which is a judicial high criticism, I think. Okay, what about this MOU then? It's not legally binding, but it is supported by a joint declaration where the governments to maintain to commit it in all circumstances, which of course begs the question, if you're going to maintain it in all circumstances, why didn't you make it legally binding? Now, what the MOU does is that it limits external borders. You can move freely. The principle is you can move freely between the jurisdictions. There are no routine migration checks. You can get checks under terrorism legislation, but the general principle is no routine migration checks. Although you will know if you come through Dublin Airport, when they built the new terminal, they made no special arrangements for the Common Travel Area. You have to go through the passport control section. So that's regulation by architecture, arguably. And finally, there's no explicit right to free movement. All that happens is that there's a special status given to UK and Irish citizens in each other's jurisdictions that triggered these rights, rather than a positive statement of the conferral of the right of free movement. What kind of rights are we talking about? Well, as the governments commit to do whatever is necessary to ensure these rights and to provide clarity on their provision. The MOU recognises flexibility, so the rights can change over time. And I think on a practical level, the rights may not be identical in both jurisdictions, partly because sometimes there's no legal basis and it's relying on administrative arrangements. And sometimes there's just there's a variation in legal framework. But there's a kind of commitment to reciprocity within those constraints. So in brief, the rights are the right of franchise, which is supported by legislation, the right to reside and the right to work and be self-employed. These rights arise out of the status legislation I've referred you to already. The rights to social protection and social housing are governed by the Convention on Social Security, which has been incorporated into domestic law in both jurisdictions. And then we have healthcare and education, which are a bit messier. Healthcare. We have reciprocal rights for emergency, routine, and planned publicly funded healthcare. And the rights are extended to posted workers, frontier workers, and students. In Ireland, it is supported by legislation, and it has also been extended to private healthcare for 1 year via administrative arrangement. And some of you who are based here may be familiar with the idea of the cataract buses going up from Kerry for people to have surgery on their eyes in Northern Ireland. It's a politically sensitive point that they want to be able to continue to do that. The Trade and Cooperation Agreement is also relevant, and at the moment there are exchanges of letters between UK and Irish officials to determine where the boundaries are on the respective health arrangements between those two agreements. I love this photo, I think it's great. Anyway, the Education MOU, we have an MOU by the quality assurance bodies of the two jurisdictions on information sharing and mutual understanding. And then I think the more significant one is the Reciprocal Education Rights MOU. Now, I haven't seen it yet. The press release came out in July. I requested a copy, but I haven't seen it yet. What we have, the only part of it of which I'm aware that has become into law is the parity of fees, which is supported by legislation and statutory instrument in both states. The Irish also unilaterally, as you may be aware, have extended the Erasmus scheme to which the UK is no longer party to Northern Ireland students and is doing this unilaterally via an administrative scheme for 1 year and has received permission from the European Commission to do this. Now, the right to work is helpful, but it's not much good if your qualifications are not recognised. And mutual recognition fell away with Brexit in relation to UK qualifications. Both states commit to comprehensive measures. I think the word comprehensive is important there, and it's been honoured in the breach more than anything else at the moment. For example, in Ireland, there's 44 bodies in Ireland that look after the professions, and they will largely self-regulate, and there are various bilateral arrangements, for example, between the respective law societies. The government officials, the minister reported to the Oireachtas that the government officials are meeting in order to discuss what can be done, and the Confederation of British Industry has cried out for a comprehensive agreement between the two states. So what we have is a highly fragmented regime at the moment and quite unsatisfactory. So what do we have? I have 2 slides left. I think it's important to remember, and I wish I could spell well, but people and trade borders are largely distinct. They're quite separate. So this would suggest that some of the tensions that we're seeing arising in relation to the trade issues on the Northern Ireland Protocol will not invade, if you like, the operation of the Common Travel Area. On the other hand, the CTA, its scope is shaky without a legally binding overarching agreement. There's a commitment to transparency, but I hope I certainly don't find it transparent. I've spent a lot of time looking at it. And that said, the citizen advice bureaus in the two jurisdictions do set it out fairly clearly as to what their citizens are entitled to. Variation is good on one level because it allows it to develop, but of course variation may lead to a diminution in rights as well. And there have been instances of that in the past, most famously in relation during World War II, but also my much loved and belated colleague Niall Osborne in a paper in 1965 noted that it was easier for an English person to get work in Dublin than to try and get a job in Northern Ireland, because there was a work permit system operating in Northern Ireland at that time. So variation thing is quite interesting. And also that we may find variations emerging, going back to Michael's discussion earlier, as devolution increases. in the UK context. Just to note that the Common Travel Area does extend, for example, to the Isle of Man and the Channel Islands, but it'll be interesting to see how it plays out with Scotland in particular, and perhaps to a lesser extent with Wales. And we saw the first taste of that, if you like, with the restrictions around COVID, which varied between each of those regions or countries. To conclude, I think the Northern Ireland Protocol does boost the legal standing of the Common Travel Area. The CTA is largely uncontroversial. I think it should survive political turbulence of the Northern Ireland Protocol. But even if it doesn't, we still have the safety net of Protocol 20 of the TFEU, which will continue the Irish opt-out. But I think the EU would need reassurance in relation to Irish EU obligations from the UK government, and I'm not sure what form would be satisfactory for that. Operationally, it works well. But to leave you with a final quote, this is from the Chief Commissioner of the Northern Ireland Human Rights Commission to the House of Commons Select Committee on Northern Ireland. He points out that the CTA is based on the understanding that the two governments will always be in a positive relationship where the Common Travel Area will be formally recognised, etc., etc. If for economic or political reasons the two governments fell out terribly badly and one said, we are no longer going to abide by that memorandum of understanding, is there very much in law that you could do to stop that? The answer would be probably no. Thank you.
Right. Thank you. Thank you very much. That was really very, very interesting. And I think we learned quite a lot there. So thank you. And without further ado, I hand over to Rory.
Thank you, Christian. Just let me echo the thanks for the smooth organization that Imelda already mentioned, and it's a pleasure to be on this panel with Imelda and Aoife virtually. So I'm going to talk about North-South cooperation, and I'm going to approach it in a historical framework, briefly looking at the history since 1921 and focusing more particularly on developments with the Good Friday or Belfast Agreement and later Brexit. I should say people I shared earlier versions of this draft with told me it was interesting but somewhat depressing. So I have tried to make it less depressing, but maybe I've gone too far in the direction of optimism, but you can tell me that during the questions. The issue of cross-border cooperation, of course, goes back to the creation of a border with partition, a border both literally, but also metaphorically, what Kathy Gormley-Heenan's called a border in the mind, which led to tensions and misunderstandings between the leaders in the different jurisdictions on the island for many years. Of course, during the 1960s, there was famously something of a period of détente or rapprochement with new leaders like Terence O'Neill and Sean Lemass exchanging visits and adopting a language that emphasized progress and economic progress. But the eruption of the conflict in the late 1960s and early 1970s, of course, quickly harmed those emerging better relations. Despite the tension that the conflict introduced, both the UK and Ireland did have interests in cooperation, both in terms of security cooperation and trying to develop responses to the conflict and build towards a peace process, but also cooperation because of their common membership of the then European Economic Community. In terms of addressing the instability in Northern Ireland, we had numerous initiatives culminating in the Anglo-Irish Agreement of 1985, which recognized a consultative role for the Dublin government in relation to Northern Ireland. That, of course, was rejected by unionists in Northern Ireland at the time. Somewhat less dramatically, but of considerable importance, was the role of the EEC and later the European Union. And we now know what was maybe not so obvious at the time, the support that the EU has provided for cooperation and for the peace process, whether it be through the creation of the European Single Market and the European Customs Union and the introduction of the Four Freedoms, the opportunities that the EU offered for soft forms of cooperation between Ireland and the UK, with an Irish ambassador saying that the officials from the two countries used to meet on average 25 times a day in Brussels. The important financial aspect, the development of common legal frameworks, and not just economic ones, but common legal frameworks in relation to anti-discrimination law, which is the topic of Aoife O'Donoghue's talk. And of course, cooperation in relation to security and the exchange of data. So the EU played an important part in terms of paving the way for the peace process, which culminated with the Belfast or Good Friday Agreement of 1998. And as everyone knows, the agreement has three strands. Strand 1 on the internal power sharing dimensions, Strand 2 on North-South relations, and Strand 3 on East-West relations. The 1998 agreement, and in the UK, the Northern Ireland Act, which gives legal force to much of the agreement, provides some detail on North-South relations. The agreement declaration of support stresses the importance of partnership, equality, and mutual respect, and highlights that the institutions in the agreement are an interlocking whole. So the success of the Assembly in the North and the North-South Ministerial Council depends on each other. Strand 2 develops North-South Ministerial Council and highlights the importance of participation in this, which is described as one of the essential responsibilities of post holders, so ministers, in the two governments. And it identifies a range of areas where the North-South Ministerial Council may discuss and provides for the possibility to create implementation bodies. And the role of the EU in relation to this is repeated at a number of points in Strand 2. Strand 3 creates East-West institutions, and specifically a British-Irish Council, again, where EU issues are a possible agenda item, and the British-Irish Intergovernmental Conference for the two governments, replacing the institutions in the Anglo-Irish Agreement. Implementing the agreement after 1998, we start with the creation of the North-South Ministerial Council, which, when it was set up, decided to focus on 6 areas. So agriculture, education, environment, health, tourism, and transport. And alongside this, 6 implementation bodies were created as well. Of course, the history of the institutions in Northern Ireland has not been without difficulties. Since then, with the Assembly formally suspended, and if not formally suspended, not effectively functioning recently for a 3-year period, which impacted on the ability of the North-South Ministerial Council to formally meet, even though steps were taken for the implementation bodies to continue to function. And even when the Assembly was up and running and the executive was up and running, there were still sometimes challenges. Most famously in 2000, First Minister David Trimble decided not to appoint Sinn Féin ministers to participate in North-South Ministerial Councils, which gave rise to a court case which decided he was using his powers improperly. In 2006, the institutions in Northern Ireland were subject to some amendment as part of the St. Andrews Agreement and the Northern Ireland St. Andrews Agreement Act. And some parts of that specifically touched on the role of the North-South Ministerial Council. So making it clear, for instance, that ministers must participate in North-South Ministerial Council meetings or make effective arrangements for another minister to participate, and putting an onus on the First Minister and Deputy First Minister to ensure there is effective participation in the North-South Ministerial Council. And the St. Andrews Agreement Act goes further and amends the pledge of office that executive ministers take so that they have to pledge to promote the interests of the whole community, to participate in the executive, and to participate in the North-South Ministerial Council and the British-Irish Council. So further enhancing the legal support for North-South cooperation. The Brexit referendum, 23rd of June 2016, came as something of a thunderbolt and has been a disruptive influence on North-South cooperation. Shortly after the Brexit referendum result was announced, the First Minister and the Deputy First Minister drafted a short letter staking out a common position, which referenced matters like the importance of protecting free movement of persons, goods and services, and highlighting the importance of EU trade and free movement of labour for Northern Ireland. And noting that many people in Northern Ireland and in the border regions have effectively a cross-border life with thousands of people crossing the border every day. The letter, while brief, was promising, but of course that promise dissipated almost immediately, and later that year, or at the start of the following year, Deputy First Minister McGuinness resigned, effectively collapsing the institutions for a number of years. While the Assembly was not functioning, the withdrawal agreement and the Northern Ireland Protocol were developed, and the protocol includes provisions to protect the agreement in all of its parts, including North-South cooperation. As part of this process, the EU and the UK conducted a mapping exercise which indicated that there were, for instance, 150 areas of North-South cooperation where EU law was implicated in some way. So the protocol that we have on Ireland, Northern Ireland, other people have written extensively about the provisions in relation to free movement of goods and customs, and we've heard about the common travel area today, and we'll hear from Aoife on the rights of individuals in Article 2. There is, in addition to the fairly detailed rules in Articles 5 to 10 of the protocol, there is also a broad, potentially important, but also somewhat vague provision in Article 11 on North-South cooperation, which says that under this protocol, under this provision, the protocol should be implemented and applied so as to maintain the necessary conditions of North-South cooperation, including in the areas of environment, health, agriculture, transport, education and tourism, energy, telecommunications, broadcasting, inland fisheries, justice and security, higher education, and sport. So that's a very extensive list of areas where North-South cooperation, the conditions for that need to be supported. It's not immediately clear, at least to me, the legal import of that, in that, unlike other parts of the protocol, we don't, for instance, have an annex which lists legal provisions of the Union that will continue to apply. Importantly, that Article 11 is not subject to the democratic consent mechanism in Article 18. So even if the Assembly does vote against the continued operation of Articles 5 to 10, this will not apply to Article 11. The protocol creates new bodies, the Joint Committee, the Specialised Committee on Northern Ireland and the Joint Consultative Working Group to review and make recommendations in relation to the operation of the protocol. And both the UK and the EU have agreed that, for instance, in relation to the Specialised Committee and the Consultative Group, the Dublin Government and the Northern Ireland Executive will be invited to participate. Katie Hayward has done a fairly thorough analysis of the operation of those entities to date, which suggests they're not entirely promising in terms of supporting cooperation, either north-south or indeed between the EU and the UK. Many unionists, of course, have expressed concern about the protocol and have urged the use of Article 18 to vote it down whenever we have a new assembly. But also, for instance, some unionists and pro-Brexit politicians have tried to litigate the protocol unsuccessfully in the Belfast High Court. A more direct challenge to North-South relations stems from the decision of the DUP to boycott North-South Ministerial Council meetings, or at least those not related to health. And this has given rise to a judicial review brought by one Sean Napier and the Belfast High Court, which concludes that the boycott is clearly unlawful. At the moment, the High Court has issued a declaration in relation to that and has not issued any sort of order as to the DUP ministers. The DUP has participated in a later North-South Ministerial Council dealing with health. And as part of that particular meeting, the Peace Plus program was also approved by the Council and referred on to the European Commission for their approval. To sum up, the story of Brexit and North-South cooperation is somewhat frustrating and one of missed opportunities in many ways. There are numerous fora for fostering cooperation between the different parts of these islands, many of them established under the 1998 agreement, though some predate it. And arguably, they haven't really been used fully effectively to ensure fruitful cooperation and dialogue. There are some reasons for optimism. Some people have pointed out, for instance, that the Irish government has started to develop links with the different UK regions, such as Scotland and Wales, but also the northwest of England. The EU and the UK have agreed to support the peace funding program with the announcement of Peace Plus. And as mentioned, the DUP did participate in the North-South Ministerial Council meeting that approved the Peace Plus meeting. The Irish government has set up a shared island initiative to look at supporting cross-border infrastructure, cross-border civil society dialogue, and cross-border research programs. And there's also other initiatives in a context where it often seems some politicians repeat old complaints that have been around for a very long time. It is important that we hear from new voices and new perspectives. And so I particularly highlight the important work being done by women's organizations. It was very refreshing to hear the UK Parliament hearing evidence from women's groups in Northern Ireland earlier in the summer. And there has now been the creation of an All-Ireland Women's Forum to look at issues affecting people and particularly women on the ground. So there is some scope for cooperation and cross-border dialogue through these different initiatives. And on that optimistic note, I will conclude. Thank you.
Thank you, Rory. Thank you for this fantastic presentation. So I think we had some great presentations here. So please don't hesitate to send me your questions via the chat function, and I will then read them out for you. But in the meantime, I thought I'll start with one question of my own to Imelda, if I may. And one of the things that I thought was really fascinating about the Common Travel Area is, of course, the Common Travel Area has been, for a number of years, one of the reasons, notably, by the Irish government for not wanting to join the Schengen area. So I was kind of wondering what you think the impact of Brexit will be on precisely this argument, because of course, as you were pointing out, there are legal issues related to the continued existence of the Common Travel Area, but the political pressure may be there for Ireland as a quid pro quo for having been supported very strongly by other EU member states in the Brexit debate, perhaps eventually to venture to join the Schengen area, and what that would then mean for the Common Travel Area, especially in the absence of having those very strong legal safeguards.
Yeah, I think because of the land border, if the EU was to insist on Ireland joining Schengen, and I'm not sure they can insist, actually, like as you say, it would be just political, not legal pressure. We would then be engaging in the same debates around the land border as we've been having in the context of the protocol. So, it would be just a different polity driving that argument. So I think the facts on the ground, as it were, work against it. I also think, I do think the geography is not just about that shared border. It has become that, but also historically Ireland and the UK are islands. And I don't know what Cyprus does actually, now that I reflect on it, or Malta, but as islands, they've always, their borders have, now it's changing in the UK, as you're aware, no doubt, and they have internal borders are much stronger than they historically were. But in Ireland, we still don't really have very strong internal borders to the same degree. By internal borders, I mean things like if you want to get a lease, your landlord has to check your migration status. If you want to work, your employer has to check your status. Those of you who examined PhD theses in the UK know the extent to which that internal border can feel very firm if you're engaging with the UK official bureaucracy around that border. We don't have borders in the same way in Ireland. So it would be a major cultural and legal shift to develop the sort of internal borders that would be required to have a completely open border with Europe. And if we had a completely open border with Europe, with mainland Europe, we would have to put a border in for the UK because it's a third country. And I think then you run into really serious questions around the Belfast Agreement and honouring that.
Thank you. That's great. So I'll encourage you to send me more questions.
If I could ask
Please.
Rory a question. Sorry, Rory. Rory, it's very confusing to see all the weight of cooperation, if you like, between Ireland and Northern Ireland and committees and etc. involved. What do you see as the most important bodies? If you had to pick your top three, which ones should we, if we want to cast an eye over this, which ones are most important, do you think? Either in the context of Brexit or in the context of the Belfast Agreement?
Well, do I have to pick one or two? That's an interesting one. I suppose the North-South Ministerial Council should be the main one, but of course there we have the DUP veto. Now the DUP are obviously being pragmatic or sensible in that health is, given the current situation, something they're not going to veto. And they obviously also decided it wouldn't be a good plan to hold up the Peace Plus monies as well. So there is a degree of pragmatism in the DUP approach there that I think is welcome. The British Irish Council and the British Irish Intergovernmental Conference, again, this is a matter of some frustration because in a sense they could be institutions that provide for East-West and North-South cooperation, especially with the disappearance of that of the EU as a forum for British and Irish officials to cooperate. But it's not clear, for instance, how seriously the British Irish Intergovernmental Conference is taken, probably by either party, maybe, well, by either party. And there was a period of quite a few years, as Aitan Tanham points out, when it didn't even meet before, even before Brexit became an issue. So that's a problem. The different, then you have the institutions set up by the protocol. You have the joint committee, the specialized committee, and the consultative working group. I know I'm not limiting myself to one or two, by the way, but I don't know that you can. The joint committee has quite a wide remit in relation to the implementation of the protocol and the withdrawal agreement. So that is important. You would like to think that the specialized committee on the protocol would be a forum to address some of the genuine concerns about the democratic deficit or perceived democratic deficit, for instance, about laws being made about Northern Ireland without the input of Northern Ireland elected politicians. So that could be a forum for quite sensible, practical work to be done and to exchange information if there's political willingness to do that. And I suppose the final thing is what I find interesting about some of the last initiatives I mentioned is that, developing links between the universities under the Shared Island scheme, or developing links between civil society groups with the Women's Forum. These sidestep the official political leadership, and North-South cooperation isn't just about the ministers. It's much more importantly about all the people, and those people who particularly want to lead cross-border lives. So I think having that sort of dialogue going on at civil society level, if it can be supported, is important and promising. Of course, you had the problem with, say, the All-Ireland Civic Forum that was announced by the Dublin government after Brexit, that the main unionist parties boycotted it. So there is still the possibility for high politics to seep into civil society relations. Sorry, that was a long-winded answer, and I know I didn't limit myself to one or two, but I think we have to keep an eye on most of these.
Thank you. And now I've got 2 questions for Imelda and 1 question for Rory. So I'll just start with Imelda so Rory can have a minute of peace before I ask the question. There is 1 question to Imelda that is kind of following up from the previous question that I asked, and is inviting you to have a thought experiment where you imagine that Ireland is now reunified. So we have Irish unification, and there isn't an Irish border anymore. So the question then is, well, that objection now no longer exists in terms of Ireland joining Schengen. What do you think would then happen? Would Ireland still maintain the common travel area? Is the attachment to the common travel area via Northern Ireland, or is it there's a traditional pattern now of migration, a certain deference, as it is put here, to those that may be British in this newly unified state? What do you think would be the outcome in terms of Schengen if there was unification?
I think we need to go back to the legislation on status and to the Belfast Agreement. So there's sort of the historic rationale around the common travel area was migration flows. The British needed the Irish workforce, and the Irish needed Britain to take its people when the economy was so depressed. I think the rationale has changed. We still have a lot of migrant flows on both sides, but there's a new impetus, which is the Belfast Agreement, and this notion of citizenship and being Irish or British or both if you're Northern Irish, and what flows from. I cannot see that changing in a unified Ireland. I think it will still be the case that if you live in a certain area within Northern Ireland, that you can still be able to choose your citizenship. And if you are able to choose your citizenship, then the Irish government, it will be incumbent on to allow those citizens to have full participation in society in the Irish state. And so I think that would create an incentive. And I think all the political indicators would be to maintain the CTA. I think the irritant, and this is really just as a punter, not as an academic, will be when you go to Europe and which queue will we be in? Well, we won't get it if we don't get into the Schengen queue. Life could be quite annoying fairly quickly, but that's an irritant in and of itself, not sufficient to redefine the relationship. And if you're interested in this, there's a really if you look at the comments of Gagan J in the Quedder case, I can't remember the year. It's in the paper. I can't remember the year off the top of my head. And he talks about how significant the common travel area is for the Irish government as a policy. And I think that's salutary in terms of understanding how important it is, even if it's very convoluted legally. So I think we'd probably have it for quite some time to come.
And then there's a follow-up question here in terms of the common travel area, whether in a sense it's complicated in any way by the fact that visas are sometimes an politically important part of the UK's offer to its trading partners, and what effect that has on the common travel area.
Yeah, I have the same question myself, actually, as I was doing the paper. How is this going to pan out? Yeah, because, and now again, this is, I haven't looked at it, it's quite difficult to get much information around the visa material, but I had noticed that like, for example, what's been happening in the UK around visas for lorry drivers. There was a variation made on rules in Ireland as well. And I think historically Ireland piggybacks like on British visa arrangements to keep them going. And they're fairly closely aligned. Like they if Butler and Barrett in their article in the Cambridge Yearbook talk about how Ireland extended visas to ride on, to take advantage of the Olympics in the UK to allow people to come to Ireland. You know, so there's a bit like some of the institutions that Rory's been telling us about, and there's a very pragmatic response, which is possible because these are administrative arrangements. And looking at some of the presentations to a committee in the Oireachtas by senior civil servants, you know, they talk about how close the relationship is, how, you know, how they're able to talk to their colleagues on the other side with alacrity. And I think one of the tragedies, I suppose, of Brexit is that they'll have to nurture that closeness in a different way now to keep things operationally effective, at least.
Great, thank you. I have a couple more questions, but I'll give you a little breather first, so that will give Rory also a chance to answer some questions. And one of the questions here is, what are your views in terms of the difference in terms of rights, whether you are Northern Irish citizen and you're a British passport holder, and in a way you have less access to rights provisions now in Northern Ireland than those who hold an Irish passport and therefore have EU citizenship rights. So what are your views about that?
Yeah, so we looked at that as part of a project I was working on with Queen's Law School and the Committee on the Administration of Justice. And I particularly recommend the work of the Committee on the Administration of Justice because they put a lot of effort into thinking about the implications of citizenship. So the conclusion we came to was that if you take seriously the notion of you can be British or Irish or both, the outworking of that should be that your rights should not depend on which identity you choose. And therefore, in our Brexit Law and I project, we suggested a best of both worlds, that whatever right Irish passport holders in Northern Ireland, who were the people of Northern Ireland, had, so should British passport holders in Northern Ireland have. And instead, of course, that's not the case. And that introduces a discrimination. So in some ways, yes, people in Northern Ireland, the people of Northern Ireland who are Irish passport holders may have access to more rights than British passport holders. So our view is that that was inconsistent with the principle in the Good Friday Belfast Agreement. But that wasn't, of course, the ultimate solution. And there's some good work done by CAJ and others. I think Colin Murray and Aoife Donahue again and Ben Warwick, trying to trace the different implications of citizenship, because what rights you have now in Northern Ireland are quite complicated. So I mentioned the rights of Irish passport holders who are part of the people of Northern Ireland, but their rights may be different from somebody who is an Irish passport holder but was born in the South, for instance. So it can be, it's a complicated picture in terms of rights and citizenships now in this jurisdiction.
Thank you. And now I have a couple more questions for Imelda. Both of them mainly related to the kind of lack of a legal framework, if you like, to the common travel area. And here, one question is in relation to the Home Office treatment of Marisosa case, does that give you confidence that the provisions of the Common Travel Area will be respected should the UK have a reason to diverge from it? And then another question that is kind of related to that is about citizens' rights under the Common Travel Area. If they're not always underpinned in law, do you think the consequence should have been taken from that, that Irish citizens should have sought or should have been permitted to seek EU settled status in Great Britain? Do you think that would have given more of a strength to their legal rights?
Oh, I'll have to defer on the EU settled status point. I know because I just don't know the law well enough on the UK end to answer it. My understanding was the Irish were encouraged not to apply for it. Were they actively excluded from applying for it? I'm not sure. And there may be others in the audience who may be able to answer that question for you. I think in relation to the first question, I understand is, is it about trust the UK government essentially around agreements and the security? Yeah. Like the Irish are guilty of this too in this particular context, because they were all very happy with the Common Travel Area MOU, but and it says very clearly it is, this is not legally binding, and just put the joint declaration beside it. Now, I think that partly reflects history. The agreement it was almost secret. The Irish government were extremely uncomfortable about letting anyone know in the 1950s, after the Second World War, when the CTA was reintroduced. They were uncomfortable about it getting out, if you like, that they were giving rights to British citizens. So, there was an exchange of letters done, but it wasn't announced in Dublin, certainly. And so maximum flexibility, maximum cooperation between civil servants, but not too much light. So on one level, the MOUs we have now are absolutely transformative, because they have shed light where there was almost no light before. So I think that is a very good thing. But the commitment to this idea, the weasel word, if you like, of flexibility, can be positive or negative, but it'll all turn on political commitment. It'll all turn it. So if relations break down between the two sides, it's extremely worrying. And the glue, if I may, that even if relations break down, there is some glue there, which is the Belfast Agreement, which I do think there is a real commitment to. What you may see is that some of the rights on the margins, in particular, can be tinkered with and may fade in some way, and that's where the problem would arise.
That's great. I have one clarification from Catherine Bernard. The Irish can apply for settled status, but they're not required. So that's the clarification. And then there is a follow-up question that is sort of linked also for Imelda about British immigration policies and whether in practice they also apply to Ireland as far as non-EU national immigration is concerned.
Yeah, the Common Travel Area is just for Irish and British citizens, not even their families. I think there's some variation around that when it comes to, I think, some social security or healthcare arrangements, but in principle, it's just Irish and just British citizens. And there is I didn't put it in, I should have put it in the thing, but there is an agreement between the Irish and British around holiday visas for Indian citizens and Chinese citizens who want to come. If you get a visa for China or for India to go to the UK, you can also come to Ireland without getting a second visa. And again, that's sort of pragmatic tourism business rather than anything else. And I think that's as far as it goes. And the UK, I should have said that the UK can, and Ireland as well, you can still be excluded as a citizen on public policy grounds. And this is made very clear in the 2020 Act on the UK side. So a public policy will trump your admittance to the state. Hence the occasional, you have to show your passport occasionally on your way in through UK airports. And many of us will have experience of that.
Right, thank you. And I think this might be an opportune moment for me to hand over to Federico.
Thank you, Christian. I know we are running out of time, so I don't need to necessarily ask my question. Okay, then I'll do it real quick. And it's a question for both Rory and Imelda. And I think, again, thank you for both of your presentations. Something that I thought was very interesting in your remarks, and I hope I'm not putting this too provocatively, but obviously the discourse around the protocol, as both of you in fact have mentioned, tends to focus on the economic provisions, and we will talk about them tomorrow. And around that, there's a lot of controversy, whether they are undermining the position of Northern Ireland within the UK, etc., etc. But if you look at other provisions of the protocol, including the ones you have focused on in your presentations today, there might be actually a dividend in those provisions for the peace process, if you will, and British-Irish relations. In a sense, legal terms, the protocol is actually codifying in a much more solid ways things that predated it. Think of the Common Travel Area, but even the Belfast Good Friday Agreement. And by making the EU a signatory to all that, is actually increasing the legal weight, if you will, of some of those mechanisms, because at the end of the day, the EU is a legal regulatory system. Everything we do in Europe is about the law. And so if you have a treaty, it's just much more than the political commitments that in the UK unwritten constitution governs things. So from the North-South cooperation mechanism in Article 11 to the Common Travel Area in Article 3 to human rights in Article 2, in fact, the protocol might ironically be strengthening some of the achievements of the Belfast Good Friday Agreement peace process and endowing Northern Ireland with actually more solid foundation there. But as I said, it might be a provocation to some extent. So I'm happy to have your thoughts.
Yes, I agree. I do think it helps. Yeah.
Yeah, I mean, it's certainly interesting, and it could help. It's interesting when you look at the different command papers the UK government has been publishing since 2020 and what they say about Article 11. They actually have very little to say about Article 11, other than a reference to saying, of course, we support cooperation and we support the peace monies, but it isn't a target for the sorts of criticisms that you have in relation to the rules in relation to Articles 5 and 10, and now the role of the Court of Justice. So I think that is positive and potentially positive. But again, Article 11, I find a very vague provision legally as to what it's actually trying to do. So part of the reason for the lack of opposition to it may also be the sense that it doesn't actually do anything very significant, and that if it did have stronger legal implications, I don't know then what the attitude in the London government would be.
Right, thank you very much. And I think now is a good time to launch Aoife's presentation.
Hello, and thank you to Federico and Randa for setting this up. I'm very sorry I can't be with you live. I'm actually traveling to the ILT and to an event on Friday, so I'm very sorry I can't be with you, but thank you, Federico, for allowing me to record my paper and to share the thoughts I have around Article 2 with you. So this paper is going to be about Article 2. We're waiting for the first cases to be heard, so it'll be partially anyway. Some of this is quite speculative, so we will have to wait and see how things play out through the various cases. But it is I suppose I want to stress what a novel and interesting article, how novel and interesting Article 2 is, how much potential it has as an instrument of human rights protection in Northern Ireland. And how significant it may be in the future. Now, the inclusion of rights and equalities provisions in the protocol can kind of seem inevitable now. But rights were, with several important exemptions, many human rights bodies in Northern Ireland and the excellent work of various human rights groups in Northern Ireland, rights were largely overlooked in the debates. However, before the referendum on Brexit had been called, there was a lot of discussion about constitutional change and reform coming out of London. And again, the potential human rights implications for Northern Ireland were clear, though it was only really towards the latter end of those discussions that the importance of Northern Ireland became really, really evident. And it's important to say the UK constitutional human rights reform does remain a possibility. And post withdrawal, and Article 2 of the protocol now joins the 1998 Belfast Good Friday Agreement as a key fulcrum of how any potential future reform of, say, the Human Rights Act occurs in Northern Ireland. Now, the ongoing question marks around this particular aspect of Brexit have three elements. First are the two strands of rights contained in Article 2. So some rights aren't specified in it. There's a reference back to the 1998 agreement, but nonetheless come with guarantees of non-diminution, while others are listed in the annex, but are dynamic, so they're subject to change and evolution. And in combination, that requires a level of kind of both vigilance as to reform and as well as enforcement mechanisms. The second important facet is the inclusion of the Northern Ireland human rights bodies, and Colin Murray and Claire Rice have written about this, about the role that the Northern Ireland Human Rights Commission, the Equality Commission for Northern Ireland, and of course the Joint Committee of the representatives of the three human rights commissions on the island, means these particular institutions now have additional roles in maintaining those rights, and are part of the function of the protocol and the withdrawal agreement, which makes it, I think, unlikely that Article 2 will be neglected, and indeed already these bodies have been active in examining the impact of Article 2. And the second reason, that second element bolsters the third, and that is that the UK is required to facilitate these functions and making these bodies, you know, they must be able to function and operate properly. And this already has had impact. There's been a reform of the Northern Ireland Act and additional funding, though the additional funding should be seen in the context of funding cuts that these bodies have had over the last while. Now, of course, Northern Ireland is absolutely no stranger to novel governance solutions, and but even within that context, I think Article 2 provides a really distinctive form of rights and equality protection. And this novelty has three strands, I would say. The first is the role of both nodular and network scales. So you have varying bodies from the devolved level right the way up to the national level across, you know, both the Republic of Ireland and the United Kingdom, across the European Union, and obviously there would be the broader international human rights requirements as well. But also within those nodules, you've got a lot of networked systems where there are links across, and formal and informal, which makes it quite an interesting, I think, aspect. The second, I would say, is the temporality that's involved. Time is quite interesting in within, because you have this non-diminution, which is a sort of a moment in time that's captured. You also have a dynamic element, which is ongoing. You also reference back to 1998, the 1998 agreement, as well as future human rights reform. So there's sort of an interesting, I think, temporal element. And I also think what's also interesting in it is the interplay between procedure and substance. So, for instance, like role of monitoring that is built within it, as well as the actual substantive content of the rights. And I think they have a really interesting interplay in this context. Now, there was always this dense network of rights and obligations operating in Northern Ireland, and I think this sort of adds to it, but kind of in a bolstering way in some ways. And I think it's creating an overlapping and often, I think, mutually reinforcing system of both process and some substantive rights that I think will be key to understanding rights protection in Northern Ireland in future, because there is now such a web of rights. Now, if you look back at the drafting, actually, Article 2's original formulation extended far beyond rights. and or far beyond the rights just impacted by Brexit, sorry, and included actionable EU rights. And now that was in the joint report, and that was tempered since, and I think it's probably not surprising that it was tempered, because the original iteration was extremely generous, being quite surprised at the time. But non-diminution became, very early on, became a settled part of the formulation. Now, sometimes non-diminution is referred to as non-retrogression or non-regression, and this is inaccurate. I think non-diminution is separate from those, while non-retrogression allows for some backward movement in very particular circumstances. Non-diminution does not. It is very, the rights are the rights on that date with no going backwards. Now, how that non-diminution will work is important, I think, because of the EU rights that go further than ECHO rights or UK Human Rights Act rights, in areas like marriage or family rights or education or asylum or data protection or health or social security, and where those are connected to the rights, safeguards and equality of opportunity sections of the 1998 agreement. Another significant aspect of that, of course, is that it brings the EU into directly into the sort of human rights protection aspects of Northern Ireland, the Northern Ireland settlement, in a way that, prior in the debates prior to the referendum and since, about whether or not the EU is essential to the 1998 agreement. And I think the way that the protocol works, it is now firmly inserted the EU into the rights aspect of Northern Ireland. Now, Section 6 of the 1998 agreement, which is the rights, safeguards and equality of opportunity, covers things like freedom of political thought, freedom of expression of religion, pursue your democratic, national and political aspirations, constitutional change through peaceful and legitimate means, equal of opportunity, which is very significant in social economic activity, regardless of class, creed, disability, gender, or ethnicity, apologies, freedom from sectarian harassment, and the right of women to full and equally participate politically. And also Section 12 is the right of victims to remember, as well as to contribute to a changed society. Now, some of these, obviously not all of them, are still underpinned by EU primary and secondary law. So the general prohibition on discrimination, for instance, or freedom of political thought, connected to Article 21 of the Charter of Fundamental Rights. And the meshing of these orders is long-standing. Now, EU law not covered by the 1998 agreement section on rights and safeguards is not covered by the non-diminution principle. However, is also covered. However, rights, this is where the annex aspect comes in particularly important, because while they are also covered by non-diminution, those rights aren't caught at that particular date of withdrawal. They are dynamic, so they are subject to change. So you have this first category of things covered by rights and safeguards, and then you have the second category of rights listed in the annex, the list of directives that are subject to change. So in scenarios where directives are amended or replaced, the UK is required to also alter the law in Northern Ireland to comply with it. Now, this will be, obviously there will be also a temporal element here, because the UK, and it's built into the system, about the time it will have and how much change will be required to comply with it. But it does bring, I think, the Northern Ireland Human Rights Committee and the Equality Commission for Northern Ireland here right to the forefront, because part of their task will be to look and monitor to see whether or not both strands of rights are maintained. And this requires, and I don't think it should be underestimated, how much work this will require of those bodies. This, will require constant kind of monitoring of UK and Northern Ireland primary, secondary, and delegated legislation, and any changes that are related to those directives. And that's a very complex and substantial undertaking, because you do have to, it's not always obvious where these rights, where the issues or questions may arise. And I do think that the complexity on an operational basis will be very significant. Now, those three bodies can, under Article 14 of the protocol, bring to the attention the Specialised Committee issues related to implementation. And this on the withdrawal agreement as well, any matter related to Article 2. And that's important because they can go directly, it bypasses any UK government filter or UK government interpretation. And I think that could be significant. The other aspect I think that potentially down the road might be significant is equivalence of rights on the island under the 1998 agreement. It's important because of the idea of the dynamic change to some of the rights, so that a gap won't open between the rights across the island. What may occur, of course, is that it could go the opposite direction. So, I mean, how likely this is questionable, but if the EU was to reduce the rights protection under the directives, then it would put Ireland in an interesting position if it had lesser rights because of these directives than what was required in Northern Ireland. Then you would have a reverse equivalence. Now, equivalence has never been tested in the court. I mean, it became a very significant issue around marriage equality and reproductive justice, and does remain an issue, I think, with regard to reproductive justice. But it hasn't been, the equivalence doesn't mean exactly the same across the island, but there is a potential there, I think, to be for it to come up. Now, to finish with, why this will be important, I think non-diminution is rarely used as a basis of rights. Now, on the face of it, that seems surprising, given the narrative of liberal continuous development of rights, and rights are always moving forward, etc., which obviously isn't necessarily true. And this sort of idea of geographical omnipotence, universality. But non-diminution, I think, is a firm example where that temporality comes into question. But also, I think, where universality almost finds its purchase. Now, it's a snapshot in time, and it can be it may in fact be an interesting measure of future change. And the choice of rights covered by non-diminution, what is captured by non-diminution in Article 2, but then the rights that aren't captured by non-diminution, will be an interesting contrast, I think, depending on how, of course, this plays out. There's also, I think, a question about the UK's future constitutional reforms, that it will go ahead, reform to judicial review and requirements of facilitation under Article 2, any future trade negotiations that may impact upon discrimination issues that may come on Article 2. And I think it'll be interesting also to see how things like the UN Universal Periodic Review of Rights looks at Article 2. I think that will be the international sort of reaction to it. I think will be interesting in those kind of bodies. And also, I think, there are discussions about what unified or reunified Ireland would mean. And I think it would be an interesting question to ask about what this might mean in reverse, what non-diminution, and I cover a bit more in the article, may mean in that context. And I think one of the most important, outcomes is likely to be a new language of non-diminution and dynamic change. I think likely to emerge there. And I think Northern Ireland might be, as it is across lots of, I think, interesting legal changes, could become very significant and very important, though much depends on what happens in practice. There are, I think, 2 cases, maybe now 3, that are going to be coming up. There's one, that are ongoing, and I think it'll be interesting to see how the courts interpret these and react to it. But yeah, so I leave it there, but thank you very much to everybody, and especially to Federico and for Andrea for doing the technical elements of it, and Federico for the invitation. And I hope the rest of the afternoon goes well.